am Apostle Nona Ray.
And I'm Apostle Glenda Ray.
And we are God's Girls, keeping it real. Well, good evening. Good evening. Welcome to God's Girls. We're so glad to have you here with us. I'm Apostle Nona Ray.
And I'm Apostle Glenda Ray.
And we are God's Girls, keeping it real. We welcome you to the show tonight, and we're super duper excited. As you all know, we have been, for the month of October, just kind of showcasing some of the candidates that will be running right here in our area in the state of Illinois.
Yeah.
And we've been introducing some of them to you and giving you an opportunity to meet them, ask questions, just find out what they do and what their plans are and all of those things like that. And so we have a very, very special guest with us today.
You know what, Apostle? I look so forward to Thursdays.
I do too.
Thursdays is, we get to meet lots of great people.
Yeah.
And especially since I've been running in the race in the campaign, Will County District 7.
Yeah.
I've met some wonderful people, and that's how we've been able to have them come on the show to just talk about some of the ins and outs of politics and
absolutely
and all of that. And a lot of that, I think, is foreign to the church.
It
feeling like there should not be the mixture of politics.
Well,
church.
We've had separation of church and state crammed down our throat for so many years.
Yeah.
And now I think the church is starting to get like the taste of it.
Mm-hmm.
But we are here with God's Girls.
Yes.
To make sure that taste changes. We are snatching food out of your mouths. Yes, we are. We want you to have something different. And so it is with great pleasure that we've had an opportunity to, like Apostle Glenda said, we meet some great people.
Yes.
And, I just tag along with her and she does what she does. But at the same time, I'm learning a lot and I'm meeting some wonderful people. So it really works very well. And so we do have someone here that, I don't call him by his full name because I'm still learning how to do that, okay? But I guarantee you by the end of the show, Apostle, I'm going to have this thing down pat, okay?
So let me then jump in so that we don't mess his name up.
It's your turn.
We have with us Associate Judge Art Smigielski, and he's running for circuit judge in the Will County area. And so we welcome you to the show today, Judge Art.
Thank you very much. The pleasure is mine to be here.
Yes.
Apostle Glenda, Apostle Nona, it is truly a pleasure to be here with you. Thank you very much for allowing me to join you.
Yes, absolutely.
So we're sitting here with an auspicious judge. I'm so proud of myself. Yes, I am. And we're going to just talk to him for a little bit for the next half hour or so, and just get him to really talk about our judicial system and what it is and what it is not and all of that. So thank you so much for coming.
Thank you.
The pleasure is ours as well. So, Apostle, do you want to start out? You have a question?
Let me start out because I caught one of your other interviews, and some of the things that you shared in that interview, it really enlightened me. It was things that I did not know. And I believe a lot of our viewing audience may not know as well. So can you speak? Well, first, let me go here. Can you tell us why you're running and why you would position yourself to move from associate judge to circuit judge in that what you're running for? Talk to us about that.
Thank you for that question. As an associate judge, my responsibilities and my duties are by and large limited to what goes on in the courtroom to which I'm assigned. Circuit judges have all of those same responsibilities, but in addition to that, circuit judges have administrative and managerial responsibilities. I think that based upon my professional and life experiences, I have a lot to add.
Okay.
I've been a lawyer in the government sector. I was with the state's attorney's office.
Okay.
I did over 2 decades in private practice of law. And in private practice of law, I was basically a small businessman. So my responsibilities were the same as perhaps yours and things you do here at the church or in your other occupations. You manage people, you
Okay.
Sure.
manage with people,
Mm-hmm.
Mm-hmm.
and you have to make sure that rules are established in your business, just as in court.
Sure.
People need to be managed. There are rules that need to be put in place. There are policies that need to be established. I think that my overall breadth of experience uniquely qualifies me among the people in this race to uh, provide that to the people of Will County. I have
Okay.
been blessed, and this is a next step. It's a next challenge. I think
Okay.
Mm-hmm.
as we go through life, we all look for our next
Our
challenge,
next.
our
Yeah,
next
we
Sure.
talk about
Mm-hmm.
that
opportunity,
all the time.
and
Mm-hmm.
I think the timing is right for me to take that next step, embrace that next challenge, and move forward
Yeah.
in my professional
Yeah.
career.
You know, I had the opportunity to meet Judge Smigielski on one occasion where I went to court with my daughter. Didn't know at the time who you were, and so when we got there, just the way that you governed the courtroom, it was just really surprising to me because when individuals go to court, they really don't know what to
Yeah,
expect. They don't know
exactly.
what kind of mood the judge is going to be in. They don't understand and don't know, I mean, how this thing is going to play out, what's going to happen. Am I going to be fined? Am I going to be arrested? So all of those things come into play in the minds of people who are sitting in the courtroom, especially those who are first timers or second timers or whatever. So I just wanted to say that you made us feel so comfortable in the courtroom and as comfortable as anybody can feel coming.
Into
And
a
by the
courtroom.
way, it wasn't criminal. It was a traffic situation that we were there for. And
Yeah.
so, but thank you for sharing that.
I appreciate your comments, and especially in a traffic courtroom, I think that people who appear on traffic tickets could be any one of us on this stage. Lord knows it was me at various times in my life.
Okay.
It's not. We're not talking about hardened criminals. It's our
Right.
neighbors. It's our
Mm-hmm.
family
Sure.
members.
Sure.
There's really no point in frightening people in that setting. If we
Mm-hmm.
can ease the tension, ease the mood, it makes it easier for all of us to accomplish the tasks we need to accomplish
Yeah.
that day.
Mm-hmm.
Um, Fear at that level, at least, I don't think it's necessary. So
Right.
thank you for your comments.
Right.
I
Yeah.
appreciate that.
So if I may ask a question, you're an associate judge at this time,
Correct.
correct?
Yes,
So
I
you're
am.
running for the office of a circuit court judge, full complement of being a judge, as I'm sure you're saying. But as far as being a circuit court judge, is there a cap on the kind of cases that you hear, the type of cases? Are there things that will not come to circuit court that might go to some different court? If you could address that, because honestly, most people again don't understand our judicial system at all.
Fair enough.
Hmm.
The circuit court is in the northern part of the state where we're at. By and large, most counties are circuits. In smaller regions, multiple counties make up the circuit. But Will County equals the 12th judicial circuit. The two terms are synonymous. Cook County is its own circuit.
Okay.
DuPage is its own
Okay.
circuit. So let's think of the circuit court as the county's court, which is the trial court level. So essentially, every conflict it starts at the circuit court level, whether that be conflict between individuals, whether that be a traffic ticket, whether that be a criminal offense. So at the circuit court level, um, we attempt to provide a peaceful forum for the resolution of conflicts.
Okay.
Sure.
Someone is ultimately going to be dissatisfied, typically,
Right.
with the results that are
Yeah.
achieved at the trial court level, the
Mm-hmm.
circuit court
Hmm.
level. So I'm seeking to be a trial court judge with the additional responsibility of managerial and administrative responsibilities.
Okay.
Understood.
If someone is dissatisfied with the outcome that is achieved in that trial court level, they have one automatic right of appeal. That automatic right of appeal is to the appellate court,
Okay.
which for our area is found in Ottawa, Illinois. Um, for most instances, that will be the final level of a case.
Okay.
People have the right to petition the Supreme Court of Illinois to hear their cases, but it's not an automatic in most cases for the Supreme Court to take on a case.
Mm-hmm.
When they do, they will. And then, of course, the Illinois Supreme Court is the law of the land, so to speak, as it relates to application of law and the interpretation of law here in Illinois.
Okay.
So if we have a dispute, we go to court. That court is at the trial court level. One of us automatically can appeal it to Ottawa. Whether we get to Springfield or not is a matter for
Okay.
the justices in Springfield to make that decision.
Okay.
Okay.
Very good.
That's very enlightening.
It
So we're
is.
talking associate level and then circuit level. And I don't know if I'm pronouncing it right in terms of levels, but then the appellate court and then the Supreme Court of Illinois.
Correct. Effectively, there are three levels of the judiciary in
Okay.
Illinois.
Okay.
Supreme is at the top, appellate is the central level, and the trial court or circuit court level. Within the trial court or circuit level, there are two types of judges.
Okay.
The associate judge, which is what my current position is, and then a circuit court judge. And again, the distinction, if you were to come in court, Apostle, right, when you came to court, there's no way you could have known, absent some unique level of knowledge, whether you were appearing before a circuit court judge or an associate.
Okay.
Our in-court responsibilities are by and large the same, and people who are in a courtroom often don't know whether the judge they are appearing in front of is an associate judge or a circuit judge,
Okay.
because the in-court duties, the manner in which the case is handled, that distinction does not apply there.
I
Okay.
see.
Okay.
Very good. And so, adding, going into the circuit court judgeship would also add managerial and administrative responsibilities that you don't currently have. Is that correct?
That is correct.
Can-
We here in Will County, and I apologize,
No,
here in
no
Will
problem.
County, we have 16 elected circuit court judges. And that's another distinction that I neglected to mention. Circuit court judges are elected by the citizens of Will County.
Okay.
Associate judges are appointed by the circuit court judges. In 2015, in March of 2015, I was honored to be appointed as an associate judge, and I have remained in that position for roughly 7.5 years.
Okay.
Mhm.
So yes, those 16 circuit court judges, they set the policies within the courthouse. They set the circuit court rules for the Will County Circuit Court. Their responsibilities, as I said, include appointment of the associate judges, but also appointment of the public defender, oversight over the public defender's
Okay.
office, the probation department, oversight over the probation department, and budgeting. I mean, there is a chief judge that's elected, but again, there are 16 circuit judges that all have a role in those various functions.
Okay. Okay.
Very good. Very
So,
good.
so in the appointment, what's the criteria for the appointment of a circuit judge to appoint an associate judge? What's that criteria? What does
I
that
can
look
speak
like?
to that from an associate's point of view.
Okay.
We fill out, I'm trying to remember, probably a 25-page application. We
Wow.
list various aspects of our professional career where we've worked. We list references both within the legal profession and outside of the legal profession. It's a rather extensive application process. The circuit judges receive the applications of all of the individuals who are applying to be associate judges. What goes on behind those closed doors, what goes on in those conferences, obviously I'm not privy to as an associate judge. But I can tell you, based on the quality of the judiciary that we have here in Will County, I can speak to our circuit judges, and our circuit judges appear to be very concerned with making sure that they not hire, but appoint
Appoint.
lawyers who have a good variety of experience,
Mhm.
who have a track record of honesty, integrity,
Hmm.
and that are well versed and well prepared to perform that job.
Okay.
I think our circuit court here has done a tremendous job in screening through those individuals and selecting individuals based on the quality of their job performance as opposed to political influence.
Okay.
That's
Okay.
very good.
Yeah.
That's very good, and that should be very reassuring to, particularly our viewers right here in Will County, that there is a push to make sure that the political side of the judge's work is kind of it's pushed to the side. That it has to be legal. It has to be according to the law, because of course, Judge. Of course, I'm sure you hear this all the time. People are always uh, assuming that something is illegal. And as we were talking, as we were getting ready for our time here today, backstage, everybody has learned the law based on Law and Order and cold case files and
Sure.
all of those kinds of things. And whereas I'm sure there may be some level of truth, it's not accurate enough to be able to talk about what a judge would do.
Yeah.
And so, again, thank you so much for straightening that out. I have a question. I'm not
Okay.
sure if you can answer, and if you can't, well, we already know what to do. We're not going to get an answer. But, however, we're going to ask this question, and then we're going to do something that we don't typically do. We're going to kind of take a little commercial break, and we're going to come back, and we're going to get an answer to this question. As we know, there's a lot of talk about the Safety Act and all of that. And the point that we want to make here today is not whether or not you're for it or against it or whatever, but I would, if you could, speak to as a judge, what do you foresee some of the challenges or maybe even some things that might help
Okay.
from that act? And so, if you could answer that when we come back,
I'd be
we
happy to.
would really appreciate it. All right. So, viewers, stay tuned. We're coming back. Go get some coffee, some tea, some water, some ice cream, some dinner, whatever you get. And we'll be back here in just a minute with our judge.
While you're going out, let somebody know that those girls are on again, and join us when we return. Thank you so much.
Hi, I'm Dr. Glenda Wright McCullum, and I'm running as a Republican for a seat on the Will County Board, District 7. The borders of District 7 encompass the west side of Joliet, extends north to Renwick Road, and west to County Line Road in Plainfield, covering over 62,000 residents. As a lifelong resident of the Joliet and Will County area, my heart beats strongly for the issues that affect the quality of life for you, the residents of Will County. This upcoming election is entrenched with many issues that affect the core values of our school system, the traditional family structure, quality and affordable housing, as well as the posterity of the county as a whole, just to name a few. My promise to you is that if I am elected, I will be a true conservative voice for the education of our youth, returning to the core values of learning that provide students with the necessary education, giving opportunity for continued growth and development, to include the critical involvement of parents. I will hold true to the traditional conservative values of marriage and family, values that support the biblical identification of male and female, as well as the preservation of life from the womb. On November 8th, 2022, I ask for your vote to elect me, Dr. Glenda Wright McCullum, as your conservative voice for Will County Board, District 7.
Well, thank you so much for staying tuned with us. We are back. And for those of you that are just tuning in, we are sitting with Judge Art Smigielski, who is running for a circuit court judge here in Will County. He is currently seated as an associate judge, and we have been in the throes of many, many questions that we've thrown at him. And just to find out the process of the judicial system and the levels of judicial system is very, very enlightening. And so before the break, we had a question that we had on the table. And so I'm going to throw it to Apostle Nona so that she can repeat the question and then give the judge an opportunity to answer that.
Thank you, Apostle. So we are just wanting the judge to talk a little bit about how the Safety Act that we have talked about extensively right here on the show, how it will affect his and the other judges' positions, and what kind of things they are kind of expecting to see as this Safety Act is approved, if it is approved. And so, Judge, if you could speak to that for us a little bit.
I sure can. And first of all, my apologies to the audience. Apparently, my tech skills have once again shown themselves for what they are. So fortunately, I'm a judge and not a tech expert. Somehow or another, I turned my microphone off earlier. So my apologies to everybody for that. I hope you can hear me better now. In terms of the Safety Act, first of all, it has passed. It is, as it stands right now, it is a law that has been in effect in certain aspects of it, and then the remaining aspects of it that have created much of the news and controversy will begin on January 1st. So in summary, what is it? It is a law that was enacted by the legislature at 4 o'clock in the morning, signed by the governor. And in terms of many offenses, it lists what offenses may be considered for detention. And by that, it means that if you have committed a certain offense, and if certain criteria within that offense are met, that you will be held without bail. No cash, no amount of money, you will just be held without bail. The vast majority of cases in the criminal field, you will just be sent home without having to post any amount of cash bail. As judges, we have the right to impose some conditions that we think might be appropriate, for example, ankle monitors, curfews, and things like that. But what has caused the most significant amount of discussion is that there are certain offenses that are not detainable. And that terminology has caused a significant amount of debate because no, the statute does nowhere within the statute does it say that any offense is not detainable. It says which offenses are potentially detainable. So if you had a black and a white tiled floor and I said to you, don't step on any black tiles, logically, you would assume that you're going to step only on the white tiles.
Correct.
But it doesn't say that any offenses are not detainable. The circumstances are such that there are many offenses that simply conditions may be imposed, but essentially people will not be able to be detained if this law remains unchanged. My job as a judge is to apply facts to the law, but it also is to apply the law to the Constitution. So whether I like a law or whether I dislike a law, that my opinion on whether a law makes sense or not doesn't matter as long as that law is determined to be unconstitutional. Right now, there are many challenges, some being led by our Will County State's Attorney, James Glasgow. I think he was the first, if not one of the first two, to file a lawsuit challenging the Safety Act. Most recent count was in excess of 50 various state's attorneys have joined that lawsuit, and my understanding is that it has been consolidated before the court in Kankakee County. So there will be a resolution on some of those issues. How quickly? We don't know. So will this law take effect on January 1? As it stands right now, I think the answer would have to be yes. I know that there are preparations being made so that there can be a proper response to the circumstances, which will be new because of the aspects of this law. So conversations are being held, and certainly you can't have a conversation about specific scenarios because each individual, each case has its own merits, but general conversations are being had so that there can be a response because it needs to be a proper response.
Yeah. So it seems as if this law even changes your ability as a judge to do some things that you probably would normally do in certain cases that now you may not be able to do because of this law. And that is a problem. It seems as if it's taking a lot of the power away from you as judges and police officers and a lot of other people down the line when it comes to criminal activity. And so again, we've talked a lot about that on the show, and I think it's important that we get the opinion of someone who is in your position and not just us who are, well, two God's girls talking about stuff. People need to hear from you that this is a game changer.
It truly is a game changer.
It
Yes,
is a
it is.
game changer. Wow.
There was an amendment to the bail statute 2017, 2018. It was called the Bail Reform Act. And there certain new concepts were introduced, pretrial risk assessments, where the probation department would have individuals assigned to interview arrestees before their appearance in bond court. That report would be provided to the judge, to the prosecutor, and to the public defender, or if the person hired a private lawyer, to their private lawyer, so that that much more information can be provided to a judge, and the judge who was sitting in bond court could make an informed decision. That law at that time created a presumption that an individual appearing in bond court should be released without having to post a monetary bail. But it was a presumption. It was not a mandate. It was not an overriding rule. And the judge, I happened to be in bond court for the 2 years that I'm speaking of, 17 and 18. So long as a proper basis was stated, the bond was applied and the bond was proper. That law also put into place that if certain categories of offenses called Category B offenses would automatically receive $30 off of the cash that needed to be deposited by an arrestee, and that arrestee would then be released. For example, if bond was set for someone at $3,000, 10% to apply, the cash equivalent of that would be $300, right, which would mean for that level of offense, if that were the bail that was sent, maximum time that person would be in custody pretrial would be 10 days. Because at 10 days, you would have the equivalent of a $300 bond.
Okay.
That was the system that replaced the original system, which was just setting bail. When you posted, you were out. When you didn't, you were not. So it was kind of a hybrid, if you will, between the bail system that existed 2016 and prior and that which is being brought into place now. So some of the scenarios that are being discussed that this will prevent the new mother who shoplifts diapers for her infant. To be honest with you, that's an insult to every member of the judiciary. It's an insult to every prosecutor. It's an insult to every defense lawyer, because in order for somebody to spend 180 days in jail for that level of an offense, Forgive me, but I'm not good enough at math to tell you what 180 times 30 is
Yeah.
in terms
Yeah.
of what that bail would
Right.
have to be. So that just was not a scenario that was ever happening.
Yeah, and that is really the kind of the flashing scenario that kind of pulls on people's hearts.
Right.
So yeah, I get it.
So at this point, then, is the law that was put in place in 2017, 2018, the bond at $30 per day, that is still current
That will be
till
until this.
January 1st.
Correct. It'll be valid up to and including December 31.
Okay.
Correct.
So now, what can you give us any specific scenarios in terms of this no cash bail? Because I know much of the public is fearful because
Mhm.
we don't understand all of the ins and outs. We don't understand a lot of the language. And so in our minds, and a lot of people are thinking that, okay, this criminal who say he's a rapist or whatever it is, a murderer, that he goes to jail, he gets arrested, and then he doesn't have to post any cash to get out of jail, that he's free until pre-trial. Is that an accurate scenario?
Perhaps not under that exact scenario, but generally speaking, yes. If it's a murder charge,
Mm-hmm.
if it can be shown by the state's attorney's office, the way the law is written, my understanding, my interpretation of it, if it can be shown that that individual poses a threat to a specific individual, that person can be detained upon the filing of the proper petition and the proper ruling. If there's no petition filed, which is not likely to happen, but it's always possible, or if there's a finding that that person does not pose a threat to a specific individual, that person would be released without having to post any cash. But there can be conditions imposed. Don't go to a certain region, wear a monitor, stay home, things along those lines. But the system that's coming is either you're in or you're out. There is no middle ground. And
Wow.
there are concerns, frankly, there are concerns from the you're in side because, again, it will have to be debated. It will have to be, and I don't know how I would rule without hearing all the arguments, but we do still have a constitution that guarantees the right to a bail.
Okay.
And that is a issue that will have to be explored. I can't predict for you how I am likely to rule on anything because I need to do the research. I need to hear the arguments if that matter were to come before me, as
Right.
does any judge.
Right.
And as I stated earlier, I may hate an outcome. Every judge, she or he has made a ruling that she or he disagrees with from a personal or moral perspective.
Mhm.
But it is our job to put that aside and to make our rulings based on what the law says, so long as that law is constitutional.
Yes. And so the real issue is whether this law is constitutional. And
That is one of many issues that are being challenged on. Yes.
yes, okay.
And so we'll have to wait for that ruling to come down to determine. And until that happens, then we are still under the guidelines of the law come January 1.
If there is no resolution of that lawsuit, until that lawsuit is resolved, this law will be in place, or unless the legislature acts. There are, I mean, we all read the news. There are talks of it being repealed, it being amended. My crystal ball is no better than yours. I have no idea what our legislature is likely to do in this fall veto session, or what's going to happen, or that may have already passed. No, I guess it's after the election, but what the next legislative assembly is likely to do, what this one's likely to do after it returns. There's no way of knowing what they'll do. They may have an idea, but we who aren't in the legislature don't know what they're going to do.
Exactly.
You know, I've heard the governor, Governor Pritzker, speak to the fact that there are some parts of the law that needs to be reassessed and looked at again to determine can we make any adjustments to this bill. My thing to that is, why wasn't that done prior to
Exactly.
it being passed? You know,
because had there not been a big blow up about this, and if there had not been people that wanted to defend, that did not want this to happen, would they have even acted?
right.
I agree. I get you.
Yeah. So you've got people that are on both sides. Obviously, the individual who doesn't have to post a cash bail,
Mm-hmm.
they're all for it. But then
Correct.
at the other side, we're looking at the public, we're looking at public safety, we're looking at the hands of the judges and the police officers being at risk, the public being at risk. There's a whole lot that's riding,
Yeah.
and it seems as though it's it's not a whole lot of understanding as to what's really underneath all of those 700 and some pages of this bill, of this law.
You said it well. I mean, it's a 750 or 760 page piece of legislation that requires a significant amount of review before anybody can truly understand it.
Mm-hmm.
Now, again, a person's like or dislike, if you're in the judiciary, is irrelevant. We'll need to rule on it based upon its merits, not
Yeah.
what our personal opinion on it might be, whether there's a particular judge who's in favor of it or a particular judge who is not a fan of it. All of that goes out the window. We have to rule based upon its legalities,
Sure.
based upon whether it's constitutional
Yeah.
or not.
Yeah.
But are there concerns? I don't know. Someone told me to read 760 pages in an hour at 3 in the morning.
Mm.
Yeah,
I don't know. I don't know. That's a lot of reading.
that's
Yeah.
a lot of reading.
That's
That's
a
a
lot
lot
of
of reading in a week.
It is. It is.
That's a lot of reading in a
It
week
really is.
on something like this.
Yeah.
Absolutely.
So that I understand, Judge. So let's kind of walk this. Say an individual gets arrested.
Mm-hmm.
They have a they don't have any priors. This is
Okay.
their first time
Okay.
being arrested. But it's a real, say it's a murder charge. Okay,
Okay.
they've never murdered anybody before.
Mm-hmm.
They get arrested. They come into court. Then where does the judge come into play in that scenario?
You're talking about the current system that we have, or are you
Okay, if you could talk about the current
Okay.
system and then
And
talk
the
about the
changes.
system that's changing.
currently? Sure. Currently, that individual gets arrested. They come to court. Um, in Will County, everybody is appointed the public defender at that initial bail hearing so that they're not appearing without representation. So whether they can or can't afford counsel, that's an issue that will be decided or discussed later. But at that bail hearing, everybody is afforded the public defender because the law says they must be, and it's a good decision because nobody should go through that stage without a
Sure.
lawyer, and there's just not a lot of time often to hire a lawyer that quickly. So under the state's attorney will present evidence about the alleged crime. The state's attorney will talk about the criminal record, if there is one, of the individual. They will discuss the course of conduct that occurred. Sometimes you'll have evidence that someone tried to flee. Sometimes you won't. But those are factors that are taken in. The public defender will then present the positives of the individual, the fact that the person maybe did not flee, maybe cooperated with the authorities. All of those factors are designed for a judge currently to take into account whether the individual who's before us poses a threat to the community, is likely to comply with court's orders, and is likely to come back to court.
Mhm.
Under the system that will take, and then we set a bond.
Yeah, yeah.
Then we set a bond, whether that bond be $1 million, whether that bond be $1,000, anywhere in between. And that's if we think that a bond is appropriate.
Mhm.
The current system still enables me to look at that mother who stole diapers so that she can put them on her newborn child because she can't afford diapers, and say you got what's called a personal recognizance or an
Right.
I-bond. We can still release people, and still do release people today without having to post any cash bail.
Okay.
So it's not that is something that is not currently being
Okay.
done.
Yes.
That example of that first offender whose child or infant needed diapers, first of all, if they were even to be arrested, if they were even to be charged,
Mhm.
the likelihood of that hypothetical individual getting a personal recognizance or being released without having to post any money is pretty good.
Yeah.
Under the system that takes effect in January, the decision is made. If the state's attorney files a petition for an identified offense, a hearing will have to be had to see if that individual's offense and the circumstances of that offense, the individual is somewhat taken out of the equation at that point in time. Not entirely, but is there a flight risk? So I guess if we see that they're trying to flee, then we can determine that but there has to be some concrete evidence that they are a flight risk today.
Okay.
And the reason that I say that, if it's not a first offender, let's say it's somebody who's done whatever type of crime, maybe not as serious as the one they're before the court now, but they've been through the system, and maybe they've got 3 or 4 priors, and they have a history of being not coming to court, ignoring court's orders. Those things can't be taken into account in determining whether they're a flight risk now or not. So there have to be specific identifiable factors in this case to determine whether that individual is a flight risk.
So it has to be just based on that case alone.
That's my
not prior
understanding. That's
history.
my understanding. And again, I don't pretend to have every answer to every question. That's why each side has lawyers. That's why arguments are made in court. But absent some identifying reason that you can determine this person to be a risk, a flight risk, and if it's a petition for a detainable offense, if I find those criteria are all met, or whoever's in bond court, that person is detained without bail. No opportunity. If they had $20 million, they cannot buy their way out of bail or out of jail on bail. If those criteria are lacking, or if the offense is not one of the identified detainable offenses, I can say you have to wear a monitor. I can say you have to stay home. I can say you have to stay away from this person or that location, but they go home, no money, no skin in the game, if you will, financially. At least.
So what's the time frame between the time of arrest and the time that they come for the bail hearing?
Within 24 hours. Within 24 hours is the arrest to the bail hearing.
Okay.
Is there ever any circumstances where it's longer than 24 hours?
Not significantly. Here in Will County, we do bond court every day, including Saturday and Sunday. Saturday and Sunday is at 9 o'clock. Weekdays, it's at 1:30. Is it possible that it could be in excess of 24? Yeah, there's that window between 24 and 48. I guess that's possible. As a general rule, people are in bond court within 24 hours. But yeah, I guess if you get arrested at 7 in the morning, they probably won't process you for the 9 o'clock that day. So you'll come in the following day. So you'll be in at 26 hours.
Got it. Yeah.
But the general rule is that someone appears in court within 24 hours of their arrest. Or within a reasonable period of time.
And so at that time, then that's when it's determined they can be detained up until
the bond
they
hearing.
appear
Well,
the bond hearing.
If it's a detainable offense. Now, if I get arrested for DUI, that's no longer a detainable offense. So the police just have to ticket me and release me.
And is that true with possession of drugs and things of that nature? Are some of those also?
I think the majority of those are not listed as detainable offenses. So by my definition, that would be non-detainable.
Okay. Wow. Got it.
And with the rise of fentanyl that's hitting our communities and the deaths that are taking place and these, I'm seeing on the news how they're confiscating all of these millions of pills these fentanyl pills and making it look like it's candy for the kids.
It's frightening.
And all of that. Something else came to me, Judge, and I know we're just about out of time, but something else came to me in the sense as you were explaining this situation. So the criminal, for lack of a better word, can potentially then have say if the ruling comes down that you are detained and this is your bail and that you cannot be released, you are detained. With this new law, what's to keep the detainee from coming back and filing a lawsuit against the county because they said this language says that you were not supposed to detain me? I mean, it could just take us into a whole different.
I can envision a scenario where someone who is detained without bail files a challenge to the law asserting their constitutional right to
Mhm.
Yes.
have bail. I can
Yes.
envision that scenario,
and
certainly.
and the workload obviously that is going to be put on our state's attorney office, the additional petitions that they have to file, all of those things that they have to do in order to validate or qualify a person to be detained. I mean, it's just going to further bog the entire system down. Not to mention more cases, as you just mentioned, court cases of lawsuits. And I mean, this is just a
Yeah.
monster of a
There are,
problem.
you're right, and we haven't even touched. We could probably spend another series of
Yeah.
programs discussing other ramifications of this law. Um, but just, I sit in a misdemeanor room right now. If somebody doesn't come to my courtroom, I have the right to issue a warrant, even the first time they fail to appear,
Mhm.
to get them back in court. Under the Safety Act, I will need to send that individual a letter. If they don't respond to the letter, we'll need to have the sheriff serve them with a petition for rule to show cause. If the sheriff has personally served them with that petition, and if they then fail to appear, then I can issue a warrant for them.
Wow.
So again, in turn, because
Wow.
one of you had mentioned the slowing down of the system and other ramifications on the
Mhm.
system. I don't know that any county's sheriff has the manpower
Yes.
to serve please come back to court
Mm.
letters
Yes.
on
Mm.
people, and then if they don't, then go back out and find that individual again to serve a warrant.
Wow.
That's a
Wow.
monumental task.
Yeah.
Wow.
Yeah.
Well, you know, Judge,
Ooh.
I mean, this is just, we could spend probably six more sessions
We could.
doing this, because this thing is just so huge. And of course, time is running out. We're getting closer and closer to January 1st.
Yeah. Yeah.
But to our audience, again, most of our audience, we are Christian people. And I want to again solicit your prayers. You
Yeah.
know,
Yeah.
our tenets of faith say that when righteousness rules, the people rejoice.
Mhm.
And this seems to be such an unrighteous and unfair and totally unsafe law that is about to hit our state. So we really do need to pray, and we ask you to share this broadcast.
Yeah.
Let's get the word out so that people will know and understand exactly not only what we're facing but what we have to get ready for, because we do have to prepare for this ruling to happen, for I'm sorry, for this law to take effect. It's
Mhm.
already signed into law.
Yeah.
And so, Judge, I really thank you so much
Thank you. It
Yes.
was
for
my pleasure.
coming, and hopefully we can get you back to talk maybe a little more about some of these things. We would love to have you come back and
I
talk to our
enjoyed it. I loved the opportunity. It was a pleasure being here with both of you and with your audience.
Yeah.
Thank you.
absolutely. Find his name on the ballot. Find him on the ballot. Go to the polls. That's what we always end our broadcast saying. Go to the polls in November. Let's make a difference.
Yes. Even the polls are open now. So early
Yes.
voting has already begun. And so you don't have to wait until November 8th. You can go and cast your vote now. And I encourage you to vote for Judge Art Smigielski. He's running for a circuit court judge in the Will County. For those of you that are in our area, Will County area, share this broadcast, because see, here's what's about to happen. Facebook has already determined that come November 1st, we can no longer broadcast anything concerning politics and concerning this election. They're shutting us down. So you need to share it now so that we can get it out. We tried to boost our last week's show. We had a couple of candidates on the show, and I tried to boost the show. They declined. They rejected the boost, and
Yes.
I thought it was because I didn't do it according to their guidelines. So I tried to boost it again, and they rejected it. And so they're probably not going to allow us to boost this show so that more of the audience can see it. And so again, share the broadcast. And I know some of you come in on the replay of the broadcast, but we've got to get this word out, and we've got to pray. We understand that the prayers of the righteous availeth much, makes tremendous power available. And so again, thank you so much, Judge Art, for coming. And we're just looking forward to the next time. We're just believing that God is going to do some powerful things come November 8th.
Absolutely. And so thank you all for tuning in. Remember, we're also on YouTube. Okay?
Yes.
All right. Well, as we always say in parting, I am Apostle Nona Ray.
And I'm Apostle Glenda Ray.
And we are God's girls, keeping it real. Have a good weekend.
We'll see you the next time.
I am Apostle Nona Ray.
And I'm Apostle Glenda Ray.
And we are God's girls, keeping it real.